Well, you just can't make this stuff up. Well, the last 24 hours has been a little different. I've had the Department of Justice and an Assistant Attorney General kind of take shots at me, which is fine. I don't do this for friends in high places. I do this so that you, the average everyday American, can know exactly what the federal government's doing to our Second Amendment every day, or your state government, or your local government, no matter what they tell us, no matter how much they gaslight us. I don't care what their party is. I don't care. If they do something good, I'll praise them. If they do something that treads on our rights, I'll criticize them. And so yesterday, Harmy Dillon made a tweet kind of calling me out, which is fine. I'm a big boy. And today she made a video telling everybody just how pro 2A, the DOJ really is, which is not a very high bar. I mean, they shouldn't be considered about being most pro this or that. They should be worried about maybe fixing all the infringements on the Constitution, not just in the Second Amendment, but all of them. While she was smoke screening us, pay attention over here, don't look at what we're doing over there, they were in court again today, defending the National Firearms Act. Yeah. Patriots, here we go again. Like, the federal government is back in court defending the National Firearms Act, saying that their suppressor registration and tax scheme is just a modest restriction. That's right. The same NFA, the same National Firearms Act that's been used for nearly a century to restrict silencers, SBRs, and other NFA items. Yep, not an infringement. And this all went down while the DOJ's Assistant Attorney General filmed that video on X to tell us just how pro 2A, the self-proclaimed most 2A friendly DOJ ever is. You don't say. I do give praise, like I said, when you do the right thing. And when it comes to the Second Amendment, I will criticize you when you tread on it, each and every time. I don't care who you are. And I will not stop, no matter who is in office or how pro 2A or how they claim to be. Coming after me is not going to change that. I also don't do this for any other reason than to get you the real news, guys and gals, unfiltered, point blank. It's just the way it is. America needs to know exactly what the government does on a daily basis. And most people don't have the time or the effort to do this stuff, so I get you the news. And if that makes me the bad guy, then say hello to the bad guy. Yeah, well, today, the department, I'm filming this now, you'll see it in the morning. Today, the Department of Justice filed its official opposition to a man named George Peterson, whose fight I've been detailing here on this channel. His conviction, he was convicted for owning an unregistered suppressor, and the pro 2A DOJ's argument, I got a bug here, they claim that the NFA's licensing and tax processing is a shall issue scheme, not an infringement of the Second Amendment. Since we now know that the DOJ, the Attorney General, and at least one Assistant Attorney General watches this channel, can y'all at the DOJ tell me any other right where you have to be fingerprinted, photographed, fill out a bunch of stupid paperwork, join a registry, and wait months to be allowed to use that right? Tweet me, since you guys like to do that. Tweet me. Now, let's break down exactly what's happening here, why this case matters, and how this could affect your right to own a suppressor nationwide. This is the truth. Here's the background. George Peterson was charged and convicted for possessing an unregistered suppressor under 26 U.S.C. sections 5841, 5861 Delta, and 5871, the same sections of the National Firearms Act of 1934 that have been the backbone of suppressor regulation for 91 years. Now, he pled guilty, but it was a conditional plea, meaning he could still appeal on constitutional grounds. And he argued that the NFA's suppressor registration requirement violates the Second Amendment. He's right, especially after the Supreme Court's landmark decisions in Heller and Bruen. Initially, the Fifth Circuit upheld his conviction, saying that suppressors aren't even arms protected by the Second Amendment. Okay, but after pushback and more filings, the panel changed its tune. Now, they assumed that suppressors might count as arms, but said it doesn't matter because the NFA's shall issue anyway, therefore it's constitutional. And that's what led Peterson to file for a rehearing en banc, which means the full court of the circuit, the full Fifth Circuit Court. He wants them to review his case. And this latest Department of Justice filing today, the one where talking about right now, this pro-2A DOJ, it's the government's official response urging the court to deny the request. How very, very pro-Second Amendment of them. The DOJ's entire position can be summed up in one phrase. The NFA's suppressor licensing scheme is presumptively constitutional. They compared the NFA to a state shall issue concealed carry system, meaning as long as you fill out the right paperwork and submit fingerprints and pay the tax, you're not prohibited, you can get approved. Sounds like shall not be infringed to me. Now they argue that since the NFA doesn't impose lengthy wait times or exorbitant fees and doesn't outright deny citizens the ability to own suppressors, then it doesn't violate Bruen. Well, guess people still waiting up to 18 months for these items isn't lengthy enough to be considered an infringement for Pam, Harmeet, and the crew. The DOJ claims the NFA process simply ensures that law-abiding, responsible citizens can possess these items, not criminals. They even cite McRory versus Garland, which was a Fifth Circuit case that upheld stricter background checks for 18 to 20-year-olds as shall issue, and therefore constitutional. Essentially, now they're saying the NFA is like getting a driver's license. Fill out the form, pay the fee, and Bob's your uncle, you're good to go. But we all know that's not the reality here, because when the federal government controls your right through a licensing process, it's no longer a right, it's a permission slip. Now, here's where it gets really interesting. Peterson argued that the $200 suppressor tax is an unconstitutional burden, and the DOJ bashed that aside, saying it's not an issue because that tax is being eliminated under the One Big Beautiful Bill Act that takes effect January 1st of 2026. Forget about it. That's the same bill that removed the federal tax on suppressors and SBRs earlier this year. So, the government is literally saying that this issue doesn't matter anymore because we've already fixed it. But think about that logic for a second. If Congress removed the tax because it was unfair or unnecessary, doesn't that suggest that the tax was a burden in the first place? Yet the DOJ insists the NFA remains constitutional, even without it. This is a slick move. I'll give them credit. It's slick. They're sidestepping the core constitutional issue by claiming it's no longer relevant due to recent law changes. They claim that the NFA doesn't target ordinary firearms like handguns, only non-essential firearm accessories that can be adaptable to criminal misuse. Well, that seems pretty 2A friendly to me, doesn't it? The government telling you or me what is essential for us and what's not essential? Well, thanks, Mom and Dad. Let's pause right there. The federal government labeling suppressors, a tool that protects hearing, improves accuracy, and enhances safety, as non-essential accessories prone to criminal use. That's rich. Then why do most every single law enforcement department in the country, every SWAT team, the DEA, the ATF, the IRS, the Postal Service, I could just keep going and going. Why do they all have them if they're adaptable for criminal use and they're not essential? And according to their logic, as long as the NFA only applies to accessories, not guns themselves, it doesn't really touch the core of the Second Amendment. That reasoning directly conflicts with how Bruen and Heller define arms as anything in common use for lawful purposes. There are millions of suppressors that are legally owned in America, hardly a fringe, non-essential accessory. But the DOJ's position paints them as dangerous, rare, and primarily used by criminals. That framing is intentional. It's designed to minimize public sympathy and judicial scrutiny. Now, Peterson argued that the Fifth Circuit's decision conflicts with Coons v. New Jersey, a recent Third Circuit case that struck down the $50 state fee that's tied to gun licensing. But the DOJ says that that's nonsense. They claim that Coons was about a state fee for handgun carry permits, not federal suppressor regulation, and that the NFA is a 90-year-old law passed under Congress's taxing power, not a modern anti-gun measure. Translation? That's a state problem. This is a federal one. Totally different. Still, this position sidesteps the heart of Bruen. that any government burden on a constitutional right must align with historic tradition. Am I right, Pam? And there's no historical analog for requiring fingerprints, a background check, a $200 tax to own a muffler for your firearm. Now, this case, it's far bigger than George Peterson. If the Fifth Circuit agrees with the Department of Justice and denies this rehearing, the ruling becomes controlling precedent, potentially making it even harder to challenge the NFA in the future. They want that circuit split, Harmeet says. Well, it takes decades in the Second Amendment to create a circuit split. That's what they want. Just go away for a couple decades. It would solidify the claim that suppressor regulation is shall issue, not an infringement, and that suppressors are non-essential accessories outside the Second Amendment's core. But if the Fifth Circuit takes it en banc and reverses, it could be a massive blow to the NFA's authority, and maybe a gut check to this pro-2A DOJ, setting the stage for a Supreme Court showdown that could finally put the NFA itself under Bruen's microscope. Now, here's what it all boils down to. The DOJ is fighting tooth and nail to keep the NFA alive. There's no other way to put it. Not because it's effective, but because it's one of the last major gun control structures from the 30s that's still standing. Now, they admit that suppressors might be arms. They admit the tax is going away. Yet they still argue the system is constitutional because it's modest. Don't remember reading that in the Constitution. Now, every time the government says that your rights are modestly restricted, it means they've already crossed the line. This isn't just about silencers. It's about whether the federal government gets to decide which parts of your firearm are worth protecting under the Second Amendment. Before I wrap up, start your morning. I'm going to need it after this. It's kind of late tonight. Start your morning with Blackout Coffee, made right here in America by patriots who believe in freedom, faith, and family. If you're tired of funding woke corporations, make the switch today. Head on over to blackoutcoffee.com/GNG, use code GNG10 to save 10% on your order, and start your mornings with a cup of freedom. We'll keep tracking this case closely, whether or not I get pushback on this video. And if the Fifth Circuit agrees to rehear Peterson en banc, that's a major signal that the NFA could be in trouble. So hit the subscribe button, ring the bell notification, and share this video, because most of the mainstream media won't touch these stories. And here on Guns and Gadgets, you'll always get the straight truth, and nothing but the truth, right from the source. Unfiltered. Always. I've been doing it for 13 years, and I'm not stopping because of a tweet. I'll see you all on the next one. Have a great morning when you see this. Take care.